Everybody has been following the trial of 2311 Racing and Front Row Motorsports versus NASCAR. Now, as a result, we have invited in Tanner Smith from Pit Box Press to the show tonight to give a full recap of what's happened after day 3 of the trial. Tanner, welcome to you. This is Motorsports' version of Amber Heard and Johnny Depp. Take it away. What have you got for us?
Well, that's quite the introduction, Josh, and happy to be here with you both and Kobe as well. Let's just get right into this. So just to take everybody back, to give everybody as much of an explainer for this whole case as I can, I've compiled as much information as I can in as concise of a way as I can. So we got to go all the way back to September of 2024, so buckle up. This case has been brewing behind the scenes of NASCAR race weekends after a take-it-or-leave-it offer from the sanctioning body made for a perilous evening for race teams. So, 2 of them, 2311 Racing, which is headed by 3-time Daytona 500 winner Denny Hamlin and NBA icon Michael Jordan, and Front Row Motorsports, primarily owned by restaurant magnate Bob Jenkins, opted not to sign the newest charter agreement proposed by NASCAR last year because they believed the sanctioning body broke federal antitrust laws by leveraging their monopoly of premier stock car racing on the race teams. This manifested in negotiations of the charter agreement that the teams claim were not held in good faith, which led to the teams receiving unfavorable terms, including, but not limited to, a continued lack of decision-making participation, their costs for showing up to the track not being covered, and critically, the charters having an expiration date of 2031, a 7-year term, unless the teams decided to sign an additional 7-year extension where their charter earnings aren't even guaranteed to change upon signing the extension, even if the media deal does go up in value. Since then, both sides lawyered up and spent much of the last 15 months squabbling amongst themselves in a North Carolina courtroom, trading barbs and evidence to prove their points with various results. This includes texts from Michael Jordan calling the other team owners, using other terms, weak for not sticking together on their shared issues. Denny Hamlin saying his despise for the France family that owns NASCAR runs rather deep, and texts from NASCAR executives where they called RCR team owner Richard Childress a, quote, stupid redneck, among other colorful pejoratives, that owes his fortune to NASCAR and that he should be taken out back and flogged. Not only that, documents found in discovery seem to indicate that NASCAR would like to abolish the very idea of team ownership and have all of the drivers under contract with the sanctioning body and not the teams. Initially, the teams won on their second filing of a preliminary injunction last December that retained their charters from 2024 for the 2025 season, as well as granting each team a third charter that they purchased from the now defunct Stewart-Haas Racing last year. But subsequent appeals from NASCAR as well as creative on-the-fly rule changes from the sanctioning body for open teams led to that preliminary injunction being nullified and voided, forcing the 6 total cars between the 2 race teams to run open for the remainder of the 2025 season. This made the season and the lawsuit financially risky for the teams. NASCAR did file a countersuit where they claimed 2311, Front Row Motorsports, Hendrick Motorsports, and RFK Racing were, quote, moving like a cartel as the teams attempted to collaborate through the Race Team Alliance, a committee where the race teams work together to advocate for the mutual interests of the teams as a whole. However, that countersuit was thrown out late October after NASCAR lost a summary judgment on the market with which this case would revolve, that market being premier stock car racing. This is because NASCAR themselves identified that very market in their countersuit, collapsing their entire argument. In essence, NASCAR, in the eyes of the court, is not seen as a competitor to other racing series such as IndyCar or Formula One, nor are they considered a competitor to other major American sports such as the NFL, NBA, WNBA, MLB, MLS, or NHL. After repeated attempts to settle the suit, The parties met in the Charles R. Jonas Federal Building in Charlotte, North Carolina on Monday morning, December 1st, to begin this trial. Jury selection featured a number of interesting moments, including a couple of potential jurors being dismissed because they couldn't be impartial about Michael Jordan, as well as a Hendrick Automotive Group employee being dismissed due to ties to team owner Rick Hendrick, a Hendrick Motorsports fan as well, that said that she could not be impartial towards Hamlin was also removed, and a NASCAR fan that said he believes the France family is killing the sport was also removed from the jury pool. Once the 6 jurors and 3 alternates were selected, Judge Kenneth D. Bell, a 2019 Trump appointee, slammed the gavel to commence opening statements. Bell took on the case following the first preliminary injunction hearing in November of last year. As the judge for that particular hearing, Judge Frank Whitney, decided to step down before the trial was fully in motion. The team's attorney, noted antitrust attorney Jeffrey Kessler, owns a historic resume that includes winning free agency rights for the NFLPA in the 1980s, as well as the very famous and recent name, image, and likeness, NIL, rights for collegiate athletes in a unanimous Supreme Court decision against the NCAA in 2021. NASCAR's attorney, conversely, is led by a familiar foe of Kessler's, Chris Yates. Yates is a member of the Latham & Watkins law firm that's representing NASCAR in this case. They also represented the NCAA in a losing effort to Kessler, as well as defeating Kessler in a very different case surrounding Major League Soccer in the United States. Kessler and Yates' associate John E. Stevenson presented their respective opening statements that morning, which led to Judge Bell limiting both sides from showing exhibits due to both sides featuring impermissible arguments. In addition, only one member of each side was allowed to be in attendance in the courtroom prior to being called up as witnesses in the case. For the teams, they selected Michael Jordan as their corporate representative, while the remaining team owners, Hamlin and Curtis Polk, as well as Bob Jenkins and Jerry Freese for Front Row Motorsports, were sequestered. For NASCAR, their corporate representative is current owner Jim France, the 80-year-old son of NASCAR founder Bill France Sr. Kessler argued that NASCAR owning a number of the tracks on the series calendar and colluding with Speedway Motorsports Incorporated to create non-compete agreements that would stop the growth of a potential competitor stock car series, as well as sanctioning agreements preventing them from hosting other racing series like IndyCar, for instance, in addition to NASCAR generating a significant amount of revenue with so little of it going to the teams, but the France Family Trust instead, which has taken in over $400 million in the past 3 years alone. Meanwhile, Stevenson's argument centered around how NASCAR was family built and how the teams are bringing the sanctioning body and its first family to court over what is essentially sour grapes from failed negotiations. The first witness to take the stand was Hamlin to free him from sequester. In testimony that lasted over the course of Monday and Tuesday, Hamlin's examination went over his background in racing and the formation of 2311 Racing, while also touching on moments that led to the lawsuit being filed. Under cross-examination, a different attorney for NASCAR, Larry Buterman, poked and prodded at the 60-time Cup Series winner about how his contracts with drivers resembled some of the hallmarks of the 2025 charter agreement he disagreed with, which led to Hamlin explaining succinctly that drivers have options to go to other race teams and sign a contract with any of them, or even hop to a different sport, while the team owners do not have that liberty, as if you buy a NASCAR Cup Series car, you are unfortunately basically locked in under the IP that NASCAR has, meaning that effectively you can't just take your next-gen NASCAR race car to a track and race it. It has to be, unfortunately, under a NASCAR-sanctioned event for the NASCAR Cup Series, so you can't just move your team and take it somewhere else, whether that be IndyCar, Formula One, etc. So, shortly after Hamlin left the stand, Scott Prime, NASCAR Executive Vice President and Chief Strategy Officer, filled in for his line of questioning, where Kessler peppered him about NASCAR striking down independently owned Speedway Motorsports Incorporated from hosting SRX races, which was the Superstar Racing Experience, a summer racing series where Tony Stewart and a number of other big wigs in racing got together a number of talented drivers from a variety of different racing series to, host events on local short tracks. Basically, what happened is when that promotion was still active, they wanted to host races at Speedway Motorsports Incorporated owned tracks, but due to NASCAR sanctioning agreements, they were unable to. In addition to that, Kessler continued to press Prime over ideas like Project Gold codes and contracts with Speedway Motorsports and their racetracks, which Prime said he had unfortunately little to no knowledge of, despite in an email where he stated that the one-year agreements they used to sign with Speedway Motorsports left their properties vulnerable to a sale or other racing series that could threaten NASCAR. Now, in court, Prime claimed under oath that the multi-year agreements are about protecting properties that NASCAR values the most. In a further round of questioning today, Kessler tilled new ground by talking about how the next-gen car was never put up to a vote by the race teams, as well as jumping into how the France family intends to own a charter in the Cup Series or multiple charters going forward, ultimately to fill a race team. Something granted to them in the 2025 charter agreement, in fact. Prime also testified that teams were told NASCAR couldn't greenlight the $720 million asking price to cover costs for the teams each year because, quote, it would bankrupt the sport. Prime also mentioned he was under the impression that his team ran the numbers before relaying that information to the teams. There was also much talk between Kessler and Prime about the initial charter agreement signed back in 2016, but Prime ultimately acknowledged that the subject was out of his depth as he had started in late 2015 with NASCAR and not in the position and capacity that he currently holds. Kessler also asked about what would have happened if the teams like 2311 and Front Row didn't sign the agreement back in September of 2024, and without saying explicitly, Prime admitted that the charter system would have been no more. Discussion was also had about how a competitor stock car series could have formed in the aftermath of the charter agreement's nullification by suggesting the prospective hypothetical racing series could race on a number of street circuits, which Kessler definitely pointed out that NASCAR lost $50 million over 3 years hosting the Chicago street race, meaning street racing for a brand new stock car racing series would not be economically viable. Kessler also approached Prime today about a number of documents that I frankly haven't had the time to go over and fully digest them, so I will be back on another show later on to update you all on the happenings. I'm assuming probably next week. Now, after Prime's exhaustive session concluded, co-plaintiff Bob Jenkins took the stand, the owner of Front Row Motorsports. The restaurant magnate testified that he has never taken a salary as the CEO of the team, and it has operated for over 2 decades. In addition to that, this means that he has not made any sort of a profit in that time period as well. Again, over 2 decades in the sport, has not made a profit and consistently loses money as part of owning this race team. Not only that, he says that the estimated losses for his race team end up around $7 million per season. He also stated that the next-gen car costs 2.5 times more than the previous Generation 6 car costs to produce, meaning NASCAR may have misled teams when they introduced the cost structure of the next-gen car that was meant to reduce costs. Jenkins also claims that teams are required to replace the nose and the tail of the next-gen car after every single event, regardless of incident, because NASCAR prohibits teams from repairing the parts themselves. During the cross-examination, NASCAR's attorneys faced Judge Bell's wrath as they violated court orders twice during their time with Jenkins. First, they brought up Jenkins' businesses outside of NASCAR, though both parties agreed prior to the case that this would not be discussed, as well as verbally bringing up a text conversation between himself and Spire Motorsports co-owner Jeff Dickerson that was previously considered impermissible evidence. Prior to court letting out this evening, Judge Bell dropped the hammer, letting both sides know that this kind of conduct will not be tolerated from either party, and warned of dire consequences if the boundaries are violated once more. The case is supposed to be lasting for 2 weeks, so it should end as far as the arguments being made are concerned at the end of next Friday, the 12th. And from there, the jury will be able to deliberate for a few days before coming to a verdict. Obviously, there have been concerns from multiple journalists in attendance based on the exhaustive list of witnesses that are, being potentially brought into this case, that there's no way this court case lasts as long as they expect it to, but I guess we'll just have to see. But that's all I've got, guys. Is there any questions in the chat that we might address about this, or any questions you guys had about it that I didn't cover in my little summary there?
I thought it was a wonderful summary, personally, as well. It's all handbags at dawn, starting up as well. Just waiting to see if anything just pop up on our screen here from the comment section. But Matt, it really is, it's all hell already to begin with, and everyone getting very heated in the courtroom.
Yes, one group of billionaires fighting another group of billionaires for millions. Make it make sense. It's very messy. It's going to get worse through next week. They should just settle this. We're just going to go round in circles. I feel like I have been and continue to be on the side of NASCAR, even though they have done some silly things and said some silly things, which probably, as I said at the weekend on another output, you don't say silly things to people in a thing that is then going to be brought back up again. If you're going to say something to someone's face and mean it, go and do it. Back to our previous comments about people on social media in NASCAR, in supercars and Formula One, because it's just going to get regurgitated and make you look silly. And I don't care that I've made myself look silly about shouting about Red Bull people over the last half an hour. Yeah, it's interesting, very interesting. I didn't think I'd get invested in this because we talked about it on the show before, and every time Kobe says, "Oh, we're going to talk about this," and I've gone, "Really?" But actually, now it's started. It's yes, very interesting stuff indeed that people are coming out with, or not being allowed to talk about, or it's being thrown straight out as soon as it gets brought in. So yeah, more to come this week, and next week's going to be interesting because we've got team owners as witnesses, which is going to be absolute grenade stuff.
Out of this comment, it's worth noting that NASCAR is putting out a daily summary of events that seem to be tailored to paint a very specific picture that's not reflected by the multitude of reporting from journalists everywhere else. Tanner, you yourself, yeah. Well, who do you trust here? I trust the unbiased opinions of people who are actually keeping their eyes on it completely as well. Tanner, what would you say as well? Is it really fair that NASCAR can be reporting on their own trial?
I mean, I fully expect them to, try to explain their side in the court of public opinion, and they definitely reserve their right to do that, and they have been doing so. I just don't think that – I know this is going to sound insane, but I don't know what their case is, genuinely. They have gone this entire trial, and I haven't been able to pick out exactly what their point is to defend themselves. They obviously have been labeled a monopoly now by the court of law. Now it's up to 2311 and Front Row Motorsports and their representation to prove that point, that they have been a monopoly unlawfully, using their power and leverage against the race teams to, kind of advance their own wealth. And I've got to be honest with you guys, I am really questioning what Latham and Watkins has been doing this entire period of time. Because you read anything that they have brought to the courtroom and you're just shaking your head like, what are you guys getting at? Like, I feel like they have not done a very good job of painting a picture of any kind. I mean, maybe if they're going for a more of an abstract painting, maybe a little Jackson Pollock, maybe they might be able to pick something out in that. But I've got to say, I feel like 2311 in front row's representation, led by Jeffrey Kessler, has been pretty tight for the most part. And I think that kind of came to a head today when they were questioning Bob Jenkins as far as NASCAR is concerned. And they've now been, quote, admonished twice by Judge Bell. And granted, I don't know what these dire consequences that he talks about are, that he can potentially levy against the attorneys of NASCAR's team. But I mean, the fact that they have been playing dirty already and it's day 3 of the trial is not exactly a glowing endorsement of how well that they've been presenting their case. Not only that, obviously, I am not in the courtroom, so I am not personally witnessing any of this as much as I would love to be there. But Jeff Gluck of The Athletic, owned by the New York Times, he is there attending with his colleague Jordan Bianchi, and he's been reporting on this during breaks in court action. And he mentioned today that during Bob Jenkins's testimony, it almost seemed like the jury was seeing Bob Jenkins as more of a sympathetic figure, which is, if you're NASCAR, the absolute worst thing you could have done. And it seems that their cross-examination has done exactly that, painted Bob Jenkins to be a likable, sympathetic figure. So, yeah, I'm just at a loss with NASCAR's defense at this point. I feel like, though, what was that?
Oh, go on. No, sorry, continue your point.
I was just going to say, I am just kind of at a loss with where they're going with this. I do think, though, that, I think any lawyer is only as good as the client that they are representing. I think that, Jeffrey Kessler, obviously, he's an amazing attorney, but even he's lost cases, even most recently to Yates and Latham and Watkins law firm in the MLS case. In addition to that, he lost the case where he was trying to argue in favor of Tom Brady not getting suspended for Deflategate back in the 2014-2015 timeframe for the NFL. Obviously, like I said, I think that a lot of these attorneys, for as good as they are only as good as the case that they are being asked to make. And I've got to be honest, I don't know if NASCAR has a case here to defend themselves, because every bit of information that has come out, including and especially the fact that there is a France family trust that gets automatically imbued with hundreds of millions of dollars every year that those people are not earning by doing anything, is certainly going to hamper their case. So, I mean, I know that I have been staunchly on the team's side this whole time, but I have been trying to go into this with as much of an open mind as possible. But every bit of evidence that I have seen come out over these past 15 months lead me to believe that the teams are on the right side of this. But ultimately, I don't know what happens to this case at the end of it if the teams win. I obviously have tried to explain what I think could happen. You can go over to pitboxpress.com and, obviously check that out. We'll try to link that in here before the end of the show. But I got to tell you guys, I'm not exactly feeling too confident about the France family's case here. I don't know if they have one.
Interesting. What I was going to say was, pick up on JJ's comment as well. It's interesting. You hear in other big court sort of reporting day after day stuff where, it's going one way and then suddenly it swings back the other way. Maybe NASCAR is hoping for that second half of the court swing, perhaps. As you say, Tanner, we're only 3 days down in this. He's going to go on probably for at least another week and a half at the very least. And then I guess we're not going to hear anything until after the Christmas break. But we could perhaps see another swing back. JJ says it doesn't even feel like chess and checkers between the two parties. It feels like the 23-11. And FRM are playing chess and NASCAR is eating the pieces, which is an interesting turn of phrase.
Oh, fond and fancy.
Checkmate.
I've
But
raised
yeah,
himself towards
it's good.
FRM and a team that has been a mainstay on the grid for 15 plus years and has won races recently in Indianapolis and Daytona. I'm on the verge of tears here. And some Matthew Owens. By the way, YouTube has started using your @ as your username. So if you don't have a username, it will show up as an @ So if we don't know who you are on your @ tell us who you are on your actual comment. We know who Matthew is because we're behind the mic. We know it's him. But yeah, Tanner, back to you.
Yeah, and actually our lovely commenter JJ Turnip is actually Jay Allen that writes for us at Pitbox Press. So nice to have
wonderful.
them.
Hello.
Yeah, nice to have them obviously percolating in the chat with questions. But yeah, I mean, especially someone like Bob Jenkins, who has worked his entire life to create this fortune that allows him to own a NASCAR team, for him to be losing $7 million a year on average is just grotesque, especially again when the France family is pocketing $100+ million a year for genuinely no reason. So yeah, it's going to be interesting to see how these attorneys continue to make their cases and weave in all these different exhibits and such. But as the Athletic, they had an attorney as a guest this week, and I'm sure she's going to be on tonight, Shannon McMenemy. She did mention in one of the post-trial videos that they've done that basically there isn't really any silver bullets or smoking guns left for NASCAR because they have tried to get this case thrown out. They've tried to obviously file a countersuit that's been thrown out. They've tried to get summary judgment to turn the case around. And by all measures, it seems that if they had a smoking gun or a silver bullet to actually point towards the race team, it seems that they would have already used it. So, yeah, and I mean, all of the stuff that we've had come out that isn't going to be used in the case, like the very interesting comments from Jeff Dickerson, Spire's team owner, about Marcus Smith that I'm not going to repeat here. Obviously the text messages about Steve Phelps and Brian Herbst talking about Richard Childress that I mentioned in the summary. Those are just exhibits that aren't even going to get used in the case, and they have been extremely explosive, so much so that Richard Childress is thinking about independently filing a lawsuit against NASCAR's upper brass. So, yeah, I like I said, I'll be very interested to see how this all plays out, but I intend to be here and help walk everybody through here as much as I can.
Just waiting to see there's some news that's coming through. Go on, Matt.
Matthew Owens with the sarcasm font on yet again there with his comment. Good evening, Mr. Owens.
Yeah.
If you're losing money every year.
That's exactly straight out of Jim France's mouth. You should just try winning more. It's like, well, we sure would like to. They are Front Row Motorsports, and they do hardly, unfortunately, start on the front row to fit their namesake a little bit more. But it's not for a lack of trying, as you can tell. I mean, that team has shown extreme incremental growth, especially over, I would say, the last 12 years or so, since they won their first race at Talladega in 2013. But even still, like, it's such a hard grind to the top of the NASCAR Cup Series, and unfortunately a very costly one. Jay says here, when NASCAR takes sponsors that are in or coming into the sport, it's kind of hard to get sponsors for a team that doesn't see much success. Hard to compete with your bosses. And yeah, it's hard to disagree. I mean, you've got to look at Xfinity, for instance. Do you think that they could be, putting more races on 2311's cars with Bubba Wallace and Tyler Reddick, who they have sponsored in the past, when they're paying, I would say upwards of $20 million to be a premier partner of the NASCAR Cup Series? You got to wonder.
Just a little bit of news that's come through as well that Best Seafood will return for Ty Dillon's second full-time season with Carlo Racing as well. So Ty Dillon definitely returning next year, and Best are returning as well. And some breaking news that's just come through about 5 minutes ago. Tanner, thank you very much for your company and the wrap up on what is a very entertaining case in the NASCAR world that's been dominating the latter half of the season. I'm sure we'll be back next week with more news as well. Thank you very much.
Indeed. See you guys.